Welcome to the NREM podcast, where we discuss the law for real estate investors. Andy and Sean are both attorneys. Nothing said in this discussion should be considered legal advice. We're simply providing information and education. You should consult with an attorney in your state regarding any specific legal issue that you may have. Hey, everybody, good morning. Today we're talking about how to resolve complex title issues through probate. I'm Andy Fowler, and I'm here with Sean St. Clair. If you're new to the show, give us a like, subscribe to our channel, share your feedback, share your likes and subscriptions with your friends. We really appreciate that. With that, we're going to go to Sean. If you would give us our legal update.
Yeah, so today I want to talk about forming LLCs in the state of operation or property ownership in order to preserve anonymity. So I've discussed before the concept of anonymity and explained that, anonymity is not truly like asset protection. I mean, it basically is what it states. It's anonymity. It provides a certain level of protection in the sense that somebody looking through the public records cannot identify who owns maybe an LLC or corporation. And in order to obtain anonymity, you normally need to file with and form your LLC in a state that provides for such, that does not require you disclose to the state who the owners of the company are, who the managers of the company are. Instead, you basically fill out a one, maybe 2-page sheet that says, here's the name of the LLC, here's the statutory agent for the LLC, and here's the person filing the paperwork. And the person filing it can be an attorney or document preparer, somebody along those lines who signs the paperwork as authorized representative or promoter or former of the company. And then that's filed, and nobody knows that it's owned by, this person or that person, or even this company or that company. Well, that's great and all, but if you then don't know how to utilize that entity, you can ruin the whole concept of anonymity. And what I mean by that is, let's say you go and you form a Delaware LLC. So you form Anonymous Delaware LLC, and that's the company, and nobody can tell who owns it. And you think, well, great, I have anonymity, I'm good to go. Well, then you take that Anonymous Delaware LLC and you start doing business in other states outside of Delaware. For example, you come to Arizona and you decide that in Arizona, I'm going to own real estate, or I'm going to enter into purchase contracts in the name of this Delaware LLC, this Anonymous Delaware LLC, because I'm anonymous. Nobody knows, that I own the company. And so I want that protection. Well, in Arizona, if you enter into, say, a purchase contract and the seller fails to perform, well, in order for you to enforce the purchase contract, and we've had a show on specific performance,
Right.
In order for you to enforce that contract, you have to go file a lawsuit for specific performance. Well, in Arizona, in order to access our court system, you cannot be a foreign entity unless you're a foreign entity authorized to do business in Arizona, which means you have to go to our Arizona Corporation Commission and file paperwork to basically domesticate your company here in Arizona. So you march on down to the Arizona Corporation Commission and you say, okay, I want Anonymous Delaware LLC to be able to do business in Arizona. And so you prepare all the paperwork. Well, guess what? Arizona is not an anonymity state. They require the full disclosure of every member manager of the limited liability company. And they require it both of domestic LLCs, so LLCs formed in Arizona, as well as foreign LLCs that are going to be doing business in Arizona or that need to be basically domesticated here in Arizona. So you're taking that anonymous Delaware LLC and you're then filing the paperwork for it to do business here in Arizona. Well, guess what? Now you need to put down in the public realm the name of the member, the name of any managers of that Delaware LLC. It doesn't matter that Delaware was, anonymous, that Delaware provide that anonymity. Arizona doesn't care. File your paperwork using anonymous Delaware LLC and list every member and manager of that Delaware LLC.
Bye-bye privacy.
Bye-bye privacy, right? So the way to go about that and avoid that circumstance is to form that Delaware LLC, but make that Delaware LLC a holding company. And then, for example, if you want to buy property in Arizona, or you want to enter into purchase contracts in Arizona, and you want to be able to, at some point, access our court system, then what you need to do is you take the Delaware LLC and you utilize that to form an Arizona LLC. So the Arizona LLC, the member of the Arizona LLC will be Anonymous Delaware LLC. And that's all you have to disclose. You have to disclose who the owner or the member of the Arizona LLC is. And in that case, you put the Anonymous Delaware LLC. You don't have to then go a level down or further and say, by the way, Anonymous Delaware LLC is owned by whoever. You don't have to disclose that because you're forming an Arizona LLC and you're disclosing the ownership or the member of the Arizona LLC as being the Delaware LLC. That's all you have to disclose. So in order to properly maintain anonymity, you should form the Delaware LLC or the Wyoming LLC. And there's other states as well that provide anonymity, but those are two of the most common. You form those, but then make those holding companies. And then if you want to do business in Arizona or any other state that doesn't provide anonymity, form LLCs in those states, but make the Delaware or the Wyoming LLC the member of those state-specific limited liability companies.
Well, I think this is such an important thing for real estate investors to consider when forming their entity, because in the past, the idea was, well, what's the chances that I'm going to end up in court? Well, they say, if you're in business long enough, you'll end up there eventually, but it's not that common. Well, we've done how many shows now on specific performance actions, partition actions? Today, we're going to talk about probate. All matters involving you being in court as a real estate investor.
Mm-hmm.
I think the likelihood is not just some off chance thing anymore. You basically need to bet on being in court at this point in this environment. And that's kind of how it's been strategically in order to be a real estate investor. So even more important to do that and not basically undo your privacy hopes by actions after you formed, right?
Yeah, that's exactly right.
All right. Thank you for that update, Sean. With that, we're going to get into the substance of our show today, which is talking about the resolution of complex title issues in the probate courts. And today we have attorney Al Nicoletti, attorney from Florida, joining us today to talk about these issues. Al, thanks so much for being with us.
Andy, thanks so much. Sean, you guys are great. I love the name of the NREM podcast, right? So a word we heard in law school and taking the bar exam, right? So thanks for having me on. Love what you guys are doing with the show and the legal community. And Sean, I got to say that was a fascinating opening when it comes to the LLC world. And this is why it's so important that you get with lawyers that focus in on these different niches, that understand this stuff, because these lawyers that think they do everything, that's a problem. Every lawyer that does everything in the book, bankruptcy, family law, corporations, you got to find the ones that really niche out in their market. And Andy, Sean, I love what you guys are doing with this show.
Well, Al, many years ago, I won't say how many, when I was in civil procedure class in law school and they were talking about in rem and personal jurisdiction, I knew one day we'd be able to use that term in rem. So thank you for noticing. Al, tell us about your practice.
So I'm in Florida. I do a ton of probate work. I love doing the probate work. It comes up in so many different real estate deals. Sean and Andy, I could tell you a whole background of how it like really all happened. But my big practice is solving complex issues that come up in these title commitments and when investors and real estate agents come across these messy deals, and I help come in, figure out what the probate issue is. Maybe we got to maneuver. Maybe we got to do something simple or complicated. But I come in to solve these problems because they can get just so messy, and we're creative with them.
Now I know your offices are out of Florida, so you're licensed there. Are you licensed anywhere else or just primarily Florida?
Nope, I'm only in Florida. That's where I am. Everybody wants me in every state for probate, but I'm only here.
So tell us how you initially got involved doing probate and real estate and the intersection of those two.
Yeah, wild story. Real estate or law was not in sight. I was always a musician for 15 years, played violin, realized that wasn't going to really take my whole career to the next level. And, you know, that's a whole other industry. I thought I was going to take the two of music and law. I was like, oh, let me go to law school, take music and law and do entertainment law. Well, I realized entertainment law was like super niched out. And so, you know, I went through law school. I tried to see what was really interesting to me. I tried different areas, and eventually, after taking the bar, I really enjoyed studying real estate. And I had an old mentor of mine that, you know, I said, "Hey, I'm really looking for a job. I just got to get my feet wet. You know, let me get in the door." He took me on. I worked with him for about a year to 2 years, and we did a lot of foreclosure stuff. And he was doing title work, foreclosure stuff. So that was the first time I really got my feet in the door when it came to real estate, seeing some of the really at the end of the foreclosure stuff that was going on. Dabbled in a little probate, saw a little probate stuff here and there, but Miami at the time when I was there wasn't the best time to learn all the probate stuff. And then it became a weird phenomenon when I had one of my best friends. He comes down, talks about probates, is like, this is a crazy cool niche to get into. And I'm like, well, you know, what are you talking about? And really accelerated from there this idea that there are so many title issues and probate problems that exist out there that people are they can't get over it because they have a problem. They don't know how to solve it. It's complicated. They're crazy. And sometimes it's not one probate, it's 6 probates. So really had that idea, really took that and ran with it. And fast forward, Andy, 5 years later, gone through over 300 probates all around Florida in all different counties, and really found myself immersed in the real estate world. A lot of probates with some bank accounts, but a lot were with the real estate and solving, moving title things over. It was crazy. And, you know, I'm speaking everywhere, and it's really been a blast getting into the real estate world. I love it. Every community that we're in, whether it's sub 2, whether it's REI SIFT, any community that we're part of locally, statewide, love the niche.
I think Sean, I think would agree that we've found that uh, the intersection between real estate and probate is just so natural. You don't expect it, but you start out in one field, and to be really good at one, you realize you gotta know both because they depending on life circumstances, you know, real estate's really most people's biggest asset, so it's gonna be part of their estate if something happens. It's just a natural thing. Al, tell us about the Al Nicoletti show. When is it, and how can people watch?
I love it. I get to plug the show. So, the Al Nicoletti show, it's crazy, Andy. You know, it all started back in the pandemic. And I realized I was like, we can't network, we can't go out and meet people. So we got to bring it, you know, on social media. So started that back 2 years ago. It's been rolling ever since. Then we went live starting last year in April, and we go live Wednesdays, every Wednesday, 9 p.m. Eastern, bringing on anybody from the industry of real estate. And like this week, I got this one guy found me on YouTube, Andy. It was crazy. He found me on YouTube off a tax deed webinar that I did like a year or two ago. And he said, man, I've been looking for this all, you know, everywhere. I'm in code enforcement. And I thought, Oh, we got to have you on the Al Nicoletti show, because like every investor wants to know about how do we reduce $1 million code enforcement lien, on a situation. So I bring on a whole bunch of guests Wednesday at 9 p.m. You can check it out on YouTube, Facebook. It's not on Instagram, but Spotify, iTunes, and Google Play. You find it on all the platforms, and the micro content comes out all the time.
All right, so let's get into probate and talk about that process, and just really kind of start at a basic level from a venue perspective. Tell us a little bit about the types of probate in Florida. Here, we've got two types: an informal and a formal. What does that look like where you're at?
So where I'm at, they got summary and formal. There's no affidavits. There's no bypass doing an affidavit like they got in Texas, or little things. I don't know if they have that in Arizona, but in
They do.
Florida, oh, they got that. See, that's great, right? I mean, that probably helps so many investors when it's just a small, simple one, and boom, you're done.
So you're going to end up in probate no matter what in Florida.
Right. In Florida, you're ending up in probate, and especially it comes up as the title requirement when you got a situation where, mom owned the property. So the what is in very simple terms, somebody owned the property, it's in their name, they died. And to get it out of their name, we have to go through the probate process, which is filling out a whole bunch of paperwork, naming the deceased, naming the heirs, naming the assets, naming the venue, what's happening, if there's any creditors. And we're filing this paperwork eventually to get a court order. And that court order moves the title over to who the heirs are. And that is what the title insurance underwriter needs to close the deal, because at that point, they'll get deeds from everybody, in and done. So the probate is just simply a word. People get scared by it, Andy. They think, oh, probate, it's like scary. It's like, no, it's just another process. And how many of you out there have dealt with 5 people, 5 sellers on one transaction? No different, except for this, you're just involving probate, just moving it over another process.
Al, I have a question for you before we jump into the title issue discussion. But it came from one of the followers of the show, and they asked, can you accomplish a novation when a property is in probate? And novations are kind of a new thing, right? That's where you have a purchase contract. So the investor enters into a purchase contract with the seller, but then the parties find another buyer for the property, and then that buyer goes around the investor and enters into a purchase contract directly with the seller, and then the investor is paid a cancellation fee or release fee for their memorandum, for example, and that's how they're compensated. They have a valid contract for the property, and in order for them to cancel, there's a consideration paid to them for that, but they don't end up closing on their contract. Instead, seller sells it to the end buyer directly under a contract directly with the end buyer. Is that something that could be accomplished if a probate's pending in Florida?
It's crazy. We're all lawyers here. In my mind, what I'm thinking, Sean? It all goes back to basics, right? The basic principle of probate. So I've never come across the novation situation before, but here's the basic. All probate's doing is the title of the property. It's not about the contracts and the close. That part all happens after the probate's done, right? All of the maneuvering and all of the shuffling with papers and assignments and novations is at the title company. Ultimately, we get back to basics, the tackling and the sacks. Probate is just moving the title out of the deceased name out to the heirs. After that part is done, the probate's done, we're out. Right. So it's just shifting the title over. And let's just say we have a situation of maybe a formal administration where we got to get the personal representative, executor, check in your state what it is. But let's just say you have that and we get the order authorizing sale. Ultimately, it depends on what's going on, what the underwriter is going to require. And that's something you can get checked out with the title company ahead of time, is what is something that the underwriter is going to want to see in that situation. But Sean, many times all we're doing is the summaries. I mean, I'd say 70 to 80% of the time it's a summary. Title shifts over, boom, done. Probate's done. Now everybody goes to do what they need to do. So I've never seen that.
So on a summary probate in Florida, does the personal representative have the power to convey the property directly out of the estate, or does title have to transfer to the beneficiaries first and then have the beneficiaries ultimately close escrow to liquidate the asset?
So in a summary, there's no PR. We've seen, like, in rare circumstances where maybe there could be a personal representative in a summary, but there isn't. All there are there's a petitioner, there could be co-petitioners, and beneficiaries. So ultimately, what you're doing in the summary is titles moving to everybody. So let's just say mom owned the property, it was the primary residence, there's no bank account, no IRA, no nothing else, and you got mom, and there's 5 kids ever. That's all we're dealing with. No spouse, no will. You know, we're going through the whole process. At that point, because it's homestead, we're moving the title over to the 5 of them. Once the probate's done and the title moves to the 5, then they can all deed out their interest afterwards, right? So we want to make sure the process is clear where the deeds are happening after that process.
So there's summary and then there's probate or a formal probate. Is that?
Yeah.
So in a formal, then there is a personal representative and they have the ability to convey the property directly from the estate to a third party then. Is that correct?
If it's homestead property, no. If it's a non-homestead property, like a vacation rental, a secondary home, land, maybe orange grove, though, that's a different story where you could have the personal representative with joinder waiver consents, everybody's on board, or formal notice at some point try to get that court order. But that's a great question, Sean, because I saw a deal one time. These investors found this one deal where there were 25 beneficiaries and there was a personal representative. The title company told them and said, hey, all you need is the personal representative to sign the deed and sign the closing docs. And then they go back to the underwriter and said, no, the underwriter wants all 25. And they were like, what are you talking about? And I said, yeah, because it's homestead property. If it's homestead property, the PR cannot sign on behalf of everybody. Lo and behold, 2.5 months later, they call me back and they say, oh my gosh, we need all 25. Oh, and by the way, in between then, 2 died. So they got to now do 2 more probates for all those people. So yeah, you got to really, that's why it's so important to work with the right lawyers that don't just think probate, that they think probate, but how to close the deal. They see the title insurance end on closing the deal.
So that raises an interesting question that we see sometimes out here, which is the concerns of beneficiaries, say in a summary proceeding, to actually go on title to the property. To me, that then creates unnecessary liability for those beneficiaries, right? They've never lived there. So what is their disclosure duty? Are they going to then be the ultimate seller of this property, sell it to a buyer gets in there, finds a bunch of problems with the property. And now instead of coming back and suing the estate, they're suing these beneficiaries individually and seeking to pursue their assets for the recovery of their damages because they were the ultimate sellers. Do you ever see where beneficiaries are like, no, I don't want to go on title, do the actual formal so that it comes directly from either the court via a court order from the personal representative, but I never want to be on title to this thing because I don't want the liability, risk, and exposure associated with that?
Yeah, great question. Actually had that come up in a recent transaction where she wants nothing to do with the homestead property. And you bring up kind of the disclaimer world where there's that form of disclaiming interest. So up until recently, there was a lot of pushback about disclaiming homestead, and it's something I got to look into about something recently that came out. But where you could use the disclaimer for homestead property, because sometimes I want nothing to do with this. We don't want anything to do with this. But the problem is that when you start using those forms, they get technical. So when you use a disclaimer, you have to make sure, is there anybody that they have any of their heirs? It starts treating it as if there's no will and they predeceased. Did they have no heirs? It goes up to parents, none of those, out to brothers, sisters. So those kind of forms, I understand when someone wants one because they don't want to get involved in it, but they are very tricky and they're very particular. Now we have one where there was an heir, but they had no children, they had no spouse, and there's brother or sister, and they want to make sure it goes to one of the sisters. That's when we can use those forms. So we've seen those situations before, but we've also seen that it can be an easy process when we get the probate done, and then the deeds they go to closing fast, right? Once the probate's done, they'll go execute deeds, they'll get that done, or they'll move it all over to one person. Or Sean, let's just say 4 of the heirs don't want any of the money, but they all want to give it to one. We could still do the probate, get them on title, but at the closing, they can all agree, when they get it witness notarized, they can all agree to bring all their money over to one. So I haven't seen many of those situations. I've been asked it before a couple times, but those forms, those disclaimers, and those different waivers have very particular ways that you have to use them.
Al, I want to get into particular types of title claims that you run into, or most common types. Let's start with this. What are the most common types of title issues that you're seeing that investors run into that involve probate?
How about this one that came up? This is really unique. So there's a piece of property. It's titled in a trust. And the investors were like, oh, well, this looks like an interesting property. What do we do next? And the next thing is like, well, where's the trust? Who has the trust? Because we need to know who's the trustee, who are the beneficiaries. Title insurance is going to want to know. Well, actually, they couldn't find the trust for quite a while until all of a sudden we found the trust, and all of the trustees in the trust are dead. So now, and of course, all the beneficiaries are alive. So think about it, Andy. Think about how many people, investors, realtors would pass off the deal. Oh, it sounds complicated. But the weird title issue that we got to get into is now taking those beneficiaries and pointing them. So now they can sign the listing. They can sign the contract. They can sign the closing documents. They would now have authority. So we see weird title issues when they're properties titled in a trust. The other thing that we see is the parents. They did a trust, but what didn't they do? They didn't deed the property to the trust. So, they put the car in the trust, they put the boat in the trust, they put, the secondary house, but they forgot the homestead property in the trust. And then the next thing you know, mom, dad, they pass, and the kids are like, oh, it's in the trust. No deed. So now they got to do probate. And now there's 7 kids. And one of them, there's always one of them is in the house and doesn't want to leave. So we see those weird things come up. Or how about another one, Andy? It was this is a classic one I've talked about on content. This whole family owned this property throughout the 50s, I think down to the 40s, and so many members of the family died, and there were never any probate was never done. But of course, somehow in like the 90s, one probate got done and put like a whole bunch of people on title. And then an investor comes along, wants to buy it, and they pull title, and they want 6 probates for one property. 6, not just one. And it's like, how many people pass that off? But how many people are crazy enough to do that kind of probate? So many different things we see. I could go through. Legal description. How about as simple as it was missing the lot number, and the title underwriter didn't like the fact it missed the lot number. Now they want to revert back and go do the probate. Quit claim deeds. How many people have seen all these, quit claim, and it's like, this one to this one, and then this one never conveyed out to this one. It just randomly did this. missing deed chain errors. And now we got to go all the way back to the original person that owned the property. And then it ends up being grandfather, and nobody knows where grandfather's death certificate is. Andy, it's wild. I mean, I've seen so much with this stuff. It's crazy.
Yeah, for some reason with the invention of the quitclaim deed, I don't know what it is, but everybody decided that was going to be the solution to every problem that they ever had. So they're like, let's just do a quitclaim deed. That'll somehow fix it. And 10 of them later, you're like, oh, you've created a problem. What are you seeing um, with title issues being created by disputes among uh, trustees or personal representatives, or disputes among individuals claiming to be and to have the authority to act and fighting in probate?
So if I know where you're going with that, we've seen a couple probates lately. I've seen about 3 of them like this, where let's just say the probate was done in Arizona, or it's ongoing in Arizona, and there's a personal representative. For some reason, sometimes the family thinks that, oh, wait, there's that property in Florida. We just need to do a deed, a personal representative's deed, and do it, get it notarized, and record it on that property in Florida, and we're good to go. 5 years pass by, and now the market's super hot, and they want to sell the property, and they go to the title company. Everybody comes to the table, and title says, well, wait a second, you got to do probate. And that's when everybody goes, what do you mean? We filed the PR deed. Why do we got to do this?
All right. Sorry about that, folks. We got an issue with the connection. We'll try to get him back. But what we were talking about and getting back into title claims that are associated with disputes among, well, they can be family members, they can be, or they don't have to be, but individuals making claims to the estate. That can be a title issue that is gonna at least slow the transaction and is gonna slow, or is at least gonna be a title issue here in Arizona that's gonna have to be resolved in a probate court as to who does have the authority, who has the rightful claim as the, successor trustee or the, rightful personal representative. Because one of the big parts of probate is, validating who has the right to act on behalf of the estate itself or the trust in probate, who can sign documents, who can transfer those and transfer those out. We still looking to get Al on? Okay, so as we wait for Al to get back on, let's talk about a couple of these. Al, we got you back?
I'm here. I don't know what happened.
I don't know. The internet gods. So let's go to we were just talking about issues of authority. Let's talk about creditor claims and dealing with creditors in probate and how that might kind of interrupt the process in probate to get that done. I assume you deal with creditor claims on the formal probate side of things. I don't know if you do it on the initial I'm sorry, I don't remember the our equivalent of the informal probate, the summary probate. How do you run into creditor claim issues and how you get those resolved?
Yeah, so we'll start with the basics. So creditors, 2 years after date of death, the creditors are out. So Visa, MasterCard, Home Depot, Medical, they're out. 2 years after date of death. Now the mortgages, major improvements, the security interest, the federal tax liens, those are sticking as long as they're all valid. But those still stick. Now, that's the easy part. Now what happens when date of death is 6 months ago? And whether it's a summary or formal, we're always trying to find out what are the known creditors, So in the summary, we want to know where are the known creditors? Are they getting mail? Are they getting notified? Visa, MasterCard, are they sending out notices? Because when we have those situations, Andy, we need to put that in the petitions so we formally notice these companies come forward and say whatever issue that they have with the assets of the estate. And in a formal administration, we're doing the newspaper publication. We could do that too in the summary, but really in the formal, we're doing the newspaper. That's addressing the unknown. and known and unknown at that point. But we want to know all of these people. We want to serve them. We want to give them the opportunity to come forward and say, hey, Best Buy. Best Buy's got a $10,000 claim. Wait a second, it's not just Homestead. There's a bank account for $100,000. Wait a second, we may be owed something. Well, then we got to analyze, what pecking order are they? Who comes? There's a class of creditors. Who comes first? Do they get paid? Do they even have a right? Let's see the bill. What's going on? I've seen very rarely. It's come up, but rarely has the creditor been motivated enough to, when we object to the claim, that they actually file an independent lawsuit to try to recover the money. Saw it with an HOA one time. Seen it in another case that's crazy, but ultimately the creditor thing, the only thing that, when it comes to the real estate world, the one thing we're thinking with creditors is, if we have any or we're dealing with any, how does this affect our timeline? Are we now going to have to say, well, instead of waiting 30 days, we're waiting 60 or 90 days? What's the timeline look like? That's the focus. It's not who is it, what is it. That's not who you're focused on. Is it going to affect the timeline? Let us know. And that's what investors and realtors and everybody in real estate loves, is upfront transparency. If this affects us, let us know. Because if I have an end buyer, I got to let the end buyer know what the delay is. And as long as we're all communicating, that's okay.
What do you see in terms of liens created as a result of Medicare or Medicaid liens because of long-term care that the deceased was receiving?
Haven't seen Medicaid or Medicare unless it's part of ACA, so which is Agency for Healthcare Administration. Once in a while, Agency for Healthcare Administration has a claim, but many times the probates that we're doing is just homestead property, so they don't have that claim to that homestead property as long as there's the requirements for homestead. So a $74,000 lien, Andy getting super picky about what the maneuvers are. Maybe everybody wants to know, well, was it the homestead property or was it secondary property? If we find out it's non-homestead property, maybe that could be an issue with ACA. Maybe they can come forward and say something. But in the formal, we're always giving notice to ACA. We're always giving notice if there's any issues. So I've seen bills come in for $1,000. I've seen some come in for $74,000. The ultimate question is, do they have a claim, or is there something here? Do we need to set it for hearing? Do we need to even get into that?
Yeah. All right. We appreciate that, Al. We're going to have to, we appreciate your time being here. We're going to have to let you go. The connection is getting difficult, and we'll see if we can try to bring you on here, but we appreciate you being here with us. And thanks so much.
Yeah. Thank you guys. Really appreciate it.
Yeah, thanks, Al. Hey, before you go, just, we can still hear you, although it's, kind of fuzzy. Just tell our audience, where they can connect with you before you head out.
Okay, so a lot of different ways. So first of all, if you want to reach me, office number is 904-999-0053. Leave a detailed voicemail. That's the perfect way. My website, www.alnicoletti.com. I'm on Facebook, Instagram, YouTube, Spotify, iTunes, Google Play. You can find the show on Twitch and a whole bunch of different mediums. But Al at alnicoletti.com.
Perfect. Well, thanks so much for joining us today. This was good. I appreciate it.
Andy, Sean, awesome stuff. Love what you guys are doing in the investor real estate community. Keep doing it.
All right. Thanks, Al.
All right. So with a little bit of the time that we have left, I thought we'd just discuss a few more of these and what we're seeing, how we work to resolve some of these. I think it's interesting, the interplay between Florida law and Arizona. It seems like there's limitations. It seems like we're able to do a lot more in Arizona and an informal probate than they can do in Florida. Just jumping off what we were just talking about with Al, what are you typically seeing with Medicare liens, or where the issue is long-term assisted care?
Yeah, what we see is that, we're going to see those liens being recorded. And then there's certain circumstances where we can either secure the release of those liens, right of survivorship. Normally, the lien won't attach if the property conveys that way. Um, Beneficiary deeds as well. But if the property is ultimately going to go to the estate or it's held by a trust, a lot of times those are going to have to be negotiated. And really, what it comes down to is what are the assets in the estate? If the property has sufficient equity, the lien claimant, the state, in this case is the state of Arizona, they're not going to want to, negotiate that much. But if there's not much available and you're saying, well, why are we going to administer this property? Why are we going to administer the estate for the beneficiaries to receive basically nothing and us write you a big check? It doesn't really make sense. Let's make it, viable for everyone involved. And then you can negotiate those away. But, those can hold up a probate. They can hold up the sale of real property. Because normally, if you can have the personal representative appointed, so here in Arizona, it's a both informal and formal probate. You have a personal representative that's appointed with the authority to sell the property. So you can have them appointed in a matter of weeks, which means the property can be sold in a matter of weeks. Well, it can't be sold if there's an access lien, what we call an access lien or a Medicare, Medicaid lien out against the property. You have to then go and obtain the release of that, or you have to go and negotiate a short payoff or other resolution to that lien.
Yeah, not all title issues are created equal. So from the investor's perspective, if the title issue is, hey, we're getting ready to close, but grandma died and grandma's not here to sign this. Well, we can get that fixed pretty quick by getting a personal representative appointed, and you may be selling that property soon. But if the issue is a recorded judgment or there's debts that are owed to the estate, well, the answer to that is, and how much those are gonna be in fixing that is, one, well, we don't know how much they're gonna be because there's a process to notifying creditors, and creditors have so many months to be able to state their claim, right? So that's not something that is gonna get fixed by a quick filing. That's gonna be a filing and then a waiting period, and then a resolution. That's not to say that with these creditor claims, there can't be some value in the property from the investor's perspective to get it done, but that's gonna take some time. So, I think it's worth noting from the investor's perspective that keep an eye out for those different title issues. If it's just an authority issue, that's gonna get resolved pretty quick. From a creditor's perspective, that may take a little bit more time. Now, what are you seeing in probate with regard to not so much a creditor claim, but what was once a creditor issue, so unreleased mortgages and deeds of trust. So we found a lien that shouldn't be here on the property. What does that look like? You've talked about that in the past,
Mhm.
just doing that to remove improper liens. What does that look like in probate?
Yeah. So what that looks like in probate is twofold. So first, you have to basically have a personal representative appointed because you need somebody to basically stand in the shoes of the borrower under that loan, right? So you need somebody who has the authority or ability to go to the, former lender, because technically they're not a lender anymore because the loan's been paid off. They just have this unreleased mortgage or deed of trust sitting out there that needs to be released. But you have to have the ability to step forward and say, oh, this borrower has passed away. I'm standing in the shoes of this borrower as their personal representative. And we're entitled to have this mortgage or deed of trust release. So you have to have the personal representative appointed. Then the second step is securing the release of that document or of that lien. So the first step in securing the release is to go to the lender or beneficiary under the deed of trust or mortgagee under the note and say, hey, look, we paid off this loan, or not we, the deceased borrower paid off this loan and you didn't release it. You need to release it. And there's other strategies that I've talked about in the past as far as like demanding a payoff statement accelerating the time period using those provisions of Arizona law. But you go to them and basically say, here are the timeframes in Arizona for you to provide certain information or to release the mortgage or deed of trust, start performing. Now, if they don't perform, then you don't have the ability to make them perform, right? I mean, that's not within your jurisdiction or power as the attorney for the personal representative, or as the personal representative, they can't make them perform. The only process to forcing compliance with the law is to have a court or a judge order them to comply, right? And so if through the normal mechanisms of sending a letter, phone call after phone call after phone call, which is what we do, right? You know, the squeaky wheel gets the grease. So
Right.
we send the letter and wait 2 days at the most, and then call up, you get that letter. Did you receive it? When can we expect a response? What are you going to do? And we do that almost on a daily basis until we finally receive a response. And of course, when we first call, it's like, we don't have to do anything. It's going to take 60 days to research. No, it's not, because you have 14 days to provide a payoff or suffer damages, or you have 30 days to release or suffer damages. So, you don't get to write the timeframes and write the rules. And, we have that conversation with them. And of course it's in our letter, but assuming that they are like, nope, we're not going to do it, and they give you the runaround, well, then you have to go into court. Well, the nice thing about probate is and this concurrent jurisdiction has a legal meaning, but just for the sake of using this term, the probate court has concurrent jurisdiction, which means it has jurisdiction to handle other claims besides probate. So those claims could be filed in the civil division of our court, or they can be filed in the probate if you have an open probate and it involves an asset of the estate. And so the probate court has the ability to hear cases that you would otherwise file in the civil division in the probate division. So you can go into probate court and say, look, judge, I'm going to file this petition in probate. I'm going to serve it on the lender. I'm going to drag the lender into probate court and say, hey, judge, look, there's this asset of the estate that we can't do anything with because this lender out here failed to release their mortgage or deed of trust, and they're not complying with Arizona law. They're not releasing it. They're not giving us a payoff to the extent they think there's amounts still owed. They're not doing any of that. So you need to make them comply. And you can do that in probate. You could also do it in civil.
Sure.
But probate has more accelerated processes many times than the civil proceeding. And so you can, potentially have a hearing, an expedited hearing, a hearing that fits better on the court's calendar than what you're going to have in civil. And so you can have that hearing sooner. You can have this issue laid out there and presented sooner. Probate courts have regular status conferences. So, you don't have to wait 60, 90 days until the response. And, you could have a status conference and the court can say, lender, show up to the status conference. I want to hear from you. And then the lender has to explain themselves to the court at the status conference as to what they're doing. So probate can be used as a tool to receive an expedited release of that mortgage or deed of trust if you cannot obtain the release outside or short of going into court.
Well, and because there's a choice of venue, that brings a variety of other considerations. One being, what law firm do you use to do that? Because when you're choosing venue, you're also talking about who's the judge. You just mentioned the processes and procedures applicable to the rules of procedure in the given court that you're trying to deal with. Not every judge is an expert. Judges in Arizona at least aren't even appointed based on their experience. It's a rotating bench. So sometimes maybe you like one in this venue versus another. So it seems to me that even in that context, there can be a lot of value to finding a lawyer who understands the probate side of things and the civil side of things outside of it when you can choose that concurrently.
Well, and I think that's what Al was hinting at
Yeah.
early on, which is, if you have multiple real estate issues or complex real estate issues in probate, you want an attorney that understands both the probate side of things and the real estate side of things. Because, there's very specific statutes dealing with obtaining the release of these mortgages and deeds of trust. And even a lot of real estate practitioners don't fully appreciate or understand the different processes available to you here in Arizona to resolve these claims. And many of the statutes are unused as far as being able to secure releases of these, deeds of trust in an expedited fashion. So you want somebody or a firm that understands that side of things, the real estate side, but then you also want a firm that understands the probate side. So, Al Nicoletti's a good example of somebody who has the experience both on the real estate side and probate side. Our firm definitely has that experience. We have attorneys that do probate, and then obviously you and I can handle the real estate side of things. And we do some probate, you and I do. Although anymore, I have Dustin Shanaker of our office do most of our probate work. But then when things become complicated from the real estate perspective, you and I are always there to work with him and the client to resolve those, whether in the probate venue or in the civil venue.
So as a real estate attorney who runs into title issues involving probate frequently, how important do you think it is to have and work with a good title company?
That is critical. Having a good title company who provides quick turnarounds, who and is cooperative, who you're able to have a discussion with the title examiners. You have a title company and you have escrow officers. And so you go to the escrow officer and you say, okay, look, so-and-so died. We have this title issue as well. We have this cloud on title. Here's what I propose to resolve this cloud on title. Here's what I propose to resolve the probate issue. And you present that to the escrow officer. Well, the escrow officer, number one, doesn't have the authority to decide that. And number two, they're just going to go straight to the title examiner who does, and they're going to say, here's what the attorney is saying. Will this work? And then the title examiner comes back and conveys some information, and then that goes to the escrow officer and back to you. It's like a game of, telephone, right?
Sure.
The message doesn't always arrive the way you want it to, both, to and from.
Yeah.
And so I've had plenty of times where I've sent a proposal, and maybe it was my fault for not like fully explaining it, so that they appreciated what I was trying to accomplish. I don't know, but it goes to the escrow officer. Then it goes to the title examiner, who's the ultimate decision maker. And then I get a response back of no. And it's like, okay. So there are some title companies who I work with regularly, who I can simply pick up the phone and I either know the title examiner and can call them directly, or B, I know the escrow officer well enough that they're comfortable putting me in contact with their title examiner. And then we have a phone call, me and the title examiner, and we discuss it. And sometimes what I proposed wouldn't work, and they'll explain why. And then they'll say, but here's the alternative, right? And then we work through the alternative and come up with a game plan. But I also have other title companies who, have been selected by someone else. Someone else selected them. I don't have the experience because we have, hundreds and hundreds of different, well, not hundreds of title companies, but hundreds of offices throughout the valley, right?
Sure,
And
yeah.
so, my experience with some, title offices, title companies is better than others. But, I haven't selected them. They don't know me from Adam. I don't know them. And so I then send my proposal on. It goes to the title examiner. I get the no back without like, well, here's what you can do, or maybe here's what you can do, but I don't like it because I don't think it'll work, or I think it's too complicated or isn't cost effective, or whatever the case may be. And I don't want to do it for one reason or the other, or I want to propose an alternative thing. So, I'll call up the escrow officer and say, hey, you responded. I'm sure your response was based upon the response you got from your title officer. Yeah. okay, well, is it possible I can talk to your title officer and kind of figure out what we can do to resolve this? And sometimes if I don't know the escrow officer or the title company, or they, I don't have that relationship with them, be like, no, we can't do that. That's against our policy. And then it's like, okay, and now we're playing, back and forth, and it becomes a lot more complicated to resolve it. So yeah, having a good title company that understands these issues, that is forward thinking, independent thinking too. I mean, I've had times where, and you see this on title reports, um, where it states that somebody's died. And so they put in there, we need letters of appointment for this person as personal representative. You're like, okay, that would work if we weren't able to do an affidavit of succession. We talked about, affidavits with Al, and in Florida, they don't have them. And in Arizona, you can do an affidavit of succession to real property under certain circumstances, which has to be, signed off on by the probate registrar, but it's not a probate. It's not an active proceeding. It's a document you file, the probate registrar accepts it, you provide it to the title company, or you record it, and that's it. Well, I've had title companies who have given the requirement of, we need letters from PR. And I've written back and said, well, this is affidavit of succession. This is what we want to do. And like, nope. Title officer said letters of appointment. It's like, no, we can do it. Nope. This is what can I speak? Nope. Well, then we have to do the informal probate and get those letters, when we could have, done it the more expedited and cost-effective manner of the affidavit of succession, just simply because that's what the title examiner put on the report. And that's all that the escrow officer was willing to consider. They weren't willing to go back and forth and work, to try to resolve this in a more expedited way.
Well, and that's the other side of this, which is when developing a relationship with a good title company, one that you can trust, who's gonna help get the deal done. That trust works both ways, because what you're establishing with the title company as well, or hoping to, is that when you suggest a fix, they can say, well, this is coming from Sean, and Sean's usually got this right. We can send this to our legal, and they're going to be like, yeah, that makes sense. Versus if you're an unknown, how do they even know? Do they even want to spend the time and everything else? So for sure, hugely important to establish that relationship with the title company in all real estate deals, but especially in fixing title issues and probate. All right, folks, with that is our episode. Thanks so much for being with us today. Next week's episode, you can be insecure, but your transaction shouldn't. We've got guest Erica Weichel from Michigan Investment Title. Look forward to seeing you guys next week. Have a good one.